Hey, how you doing? Just had to drop Janine off in Newcastle there, city centre. So I thought I'd do a quick video as I'm going home. Been so busy with loads of court stuff and my own as well, you know. Got an accepted, because you have to apply for them, but I got an accepted judicial review, so I've got one of them going on for me, but I've got two others as well. Well, one's a judicial review and the other one's a full-on appeal in Chancery. But we have three filings I've actually done in Chancery this week. So this is the first week in June. So it's been really busy. Now here's the thing. These hang on. Oh, that was a big bump. These filings in Chancery, one of them is like I suppose it is a debt, but it's a possession. We stopped the possession with a private trust deed, so we stopped that. But now we've actually like it was tied in with like a money order as well, so we've done like a judicial, not a judicial review, an appeal on the money order, because it wasn't done correctly, you know, completely wrong. Oh, I've got to go in this lane. Oh, they've remarked these lanes. Yeah, so it's been like really interesting. And then the swap lane there, it's all new and really busy. And we've had several good wins in the county court, which is what I'm trying to get people to stay away from now. Oh, thank you. Get over there. I actually have to go the time off. I should go that way, shouldn't I? I'm talking to myself there, just making sure I stay in the correct lane. Yeah, so you know, we've been we've been like filing in the way that we can actually get these claims to go into the right court. So we're starting to have a massive kickback, I suppose you could call it a kickback, or a fight back anyway, from the debt collectors. You know, they're starting to panic a bit because they're getting like a lot more work now, because people are standing up to them more. And like I say, it was like we have had some good wins, but we had a couple of like I would just say setbacks, not losses, because we don't lose. Well, that's the whole thing, the whole point about it. All right, we either win or we learn. Refuse to lose. So the people that actually did that went on to learn. So now I need to actually do some sort of like chats with them, some training with them, and because obviously what happens is the debt collectors come up and use these nonsense claims, you know, that like, well, you can't have a deed of assignment, for instance, because we haven't got a deed of assignment, and there's nothing with your data on. Well, the whole point is we're actually doing a data breach. So if the whole point of the data breach is, if they are processing your data, then they need to have what is called a legitimate interest, and they will rely on the legitimate interest under GDPR Article 6, and it says, you know, without a consent there has to be a legitimate interest. So you either consent to it, right, that they're allowed to have your data, or there has to be a legitimate interest for them to be processing it without your consent. So here's the thing. So like, if you're there and you've gone into the court defending it as well, really, but listen to the actual filing that we've put in for a data breach. Well, you're breaching my data. You shouldn't have my data because there is no legitimate interest for you to be processing my data. Their response is, yes, there is. You know, we have purchased your debt. So then in the court, they're saying, well, we haven't got a deed of assignment, so we don't need to give you the deed of assignment. And then the judges, which are like, they're obviously influenced and under pressure from the corporations, and probably as well, you know, they don't want to do what's not normal. They normally just go, right, boom, rubber stamp it, take it away, there's your CCJ, you owe a debt collector. That's the norm, that's what normally happens. But the fact is, right, that they haven't got a legally executed deed of assignment, and you know, they're completely got absolutely no legitimate interest whatsoever to be processing your data. That is the point. That is our claim that we're making. There is no legitimate interest, therefore they should not be processing the data. They shouldn't have it at all. And if they haven't got any legal title, a notice of assignment is not a legal title, right? But you've got to be able to know how to describe these things to a judge that's bored, under pressure, influenced by corporations, and you need to be able to put them in a way, and in a lot of ways, you know, they're just not equitably trained, which is why we focus completely on equity, which is a separate jurisdiction, a separate like total section jurisdiction of law. It's not common law jurisdiction, it's not statute. But the judges are just like, well, I'm not bothered, I'm not on board, you know, I want to go home, like, you know, get my caseload out of the way and get, you know, get back home, get a bottle of wine, and then leave myself until tomorrow, you know. So you've got to put them in a position where to actually do anything apart from finding your favour is embarrassingly stupid. So you need to put them in that correct position with your correct language and the words. So if they've turned around and they're going to say to you, well, we haven't got a deed of assignment, and this is in a bloody court, right? So they've said, we haven't got a deed of assignment, so we can't give you that. So on your SAR, you're requesting a deed of assignment, but we haven't got one. You know, I mean, talk about a smoking gun or shooting yourself in the foot or any other analogy you want to use. They've just admitted they've got no legal title to your debt, right? They cannot tie you with a legal title to what they're actually trying to enforce. They are literally saying, we're going to enforce this document upon you, but we haven't got it, right? We are going to enforce this document upon you, but we haven't got it. That is what they're saying in a different way. So the answer, as soon as anything like that is said, you know, would be straight, you know, with respect, Your Honour, you know, I would like to point out that without the legally executed deed of assignment, if they're saying that they haven't got one, they have actually just told you point blank that they do not have a legitimate interest to be processing the data, because to have a legitimate interest, they must have the legal title and chain of title and proof of title. So without the legally executed deed of assignment, if they're saying they don't have one, then therefore they have no legitimate interest, therefore they have breached my data, therefore you must find in my favour. There is no deed of assignment, therefore there is no legitimate interest, there is the breach. I have filed a breach of data claim. There you go. Now he can't turn around and say, oh well, no, we're not doing that, because the debt collector's just said it. We haven't got a deed of assignment. But you've got to know how to actually answer that. You know, to sit there and go, well, I've put my paperwork in. Do you know what I mean? Paperwork is one thing, but you need to be able to fight your corner. Alright? And you need to have the confidence ready to be able to do that as well. So, you know, we're actually in our private group now, we're going to do some role play. We're going to start really role playing, going over how to actually do this. You know, I think what I might do as well, we're going to do it online obviously, because people all over the country, all over the world actually, you know, got people in Australia, New Zealand, South Africa, United States, one of these countries in the middle of South America, couldn't pronounce it, you know, all over the place. But obviously mainly in England, Wales, Scotland and Ireland, and some in the north of Ireland, not Northern Ireland, right? That's a crown lie. But anyway, so but yeah, we're gonna, I think I might set up an actual a tour to do role play of how to actually do it properly in the court, how to respond for when they say things like that. And also the other one, they said, well, this is, I can't remember which one it is now. They said, like, you know, was it Cabot, PRA, Lowell, not sure now, can't remember. But they said, well, we haven't got an individual deed of assignment. I mean, they're admitting it, but the judges are just letting them say that. It's embarrassing. So they said, we haven't got a deed of assignment like individual like that. We just have a spreadsheet, and on the spreadsheet we've got hundreds of different names and addresses, and we can't show you that because that means we'd have to redact all the other names and addresses. I mean, that is like showing you so many different things. We have a spreadsheet. What does that mean? It means they haven't bought your debt, they've bought block data, right? It means they haven't actually got a legally executed deed of assignment. They've got a spreadsheet with hundreds of names on that they got off a website, right? Talk about like them saying, oh, you got a template off a website. They're buying all your, like, your data off a website, for God's sake, man. But the same response would be, well, excuse me, Your Honour, can I, you know, with greatest respect, but, you know, they've just admitted there that they have not got a legally executed deed of assignment for my name. They have got no debt that is actually tied to me, and that can actually have a legal title going back to me. If it's all they have is a spreadsheet, which is a block of data, they have no legally executed deed of assignment. If they have no legally executed deed of assignment, then there is no legitimate interest at all for them to be processing my data. We have filed a breach of data claim. If they have not got the chain of title leading back to me for that actual debt, then therefore there is no legitimate interest. That is a breach of data. I have filed a breach of data claim. I respectfully request now that you just find in my favour and you know, close the case in my favour now. You know, so, and words to that effect. I mean, I'm just taking this off speaking literally just off the top of my head. But I mean, if you rehearsed it correctly, you know, and had it a few times so that it was smooth, and, you know, just sitting in a car making it up off the top of your head, you know, obviously it is the correct answer. It might not be the most eloquent words in the world, but that's 100% lawfully and legally correct. There is no legally executed deed of assignment, therefore there is no legitimate interest, therefore you have no right to be processing or sharing my data whatsoever. So you've won your case. Oh, come on, am I in the wrong bloody lane? No, I'm not. You just didn't want to move. That's me speaking to myself again. Alright. I think I want to get into that lane there though. So, you know, but that's experience as well as just that little bit of actual extra bit of knowledge. But the experience, you know, tied in with the knowledge of how to actually answer these statements, really. They're not questions or accusations or anything, they're just a statement. And you need to be able to answer them. And, you know, the thing is, right, we've got several cases now that have been filed in Chancery. And when they go into Chancery, the people that are going to be going in are going to be so well rehearsed and trained on how to speak that they won't get bamboozled and tripped up by these lying scumbags of these solicitors, you know, for the debt collectors that come out with this absolute BS, you know. So it'll be a lot easier for them to actually cope. I think I might actually be in the wrong lane here. Let me squeeze over there. Right. Yeah, so, you know, and the thing is, this is how important this is. So everybody at the moment, if you're dealing with a debt case, and you'll know what I'm talking about if you've ever done it, and you'll be actually relying on Van Linn versus Pelias Construction Limited, you know, with Lord Denning, all talking about the deed of assignment, where they said, well, if the deed of assignment is challenged, you must show the deed. You know, but that case there from, can't remember now, 1969 was it? Then it wasn't talking about GDPR. This is the thing about, and this is the essence of it. So remember this two things here, look. The Law of Property Act 1925, when it's talking about the deed of assignment, and also, right, that ties in with the Law of Property Miscellaneous Provisions Act 1989. That's the description of how you actually transfer a debt with a deed of assignment, a real deed where it has to be signed correctly and witnessed independently. But they try and lie about that. And but Law of Property Act 1925, and also, you know, that Van Linn case, themselves, both of them were before GDPR. GDPR didn't exist back then. So now we have this GDPR, which is extremely powerful. And we need some case law set precedent with that. Now obviously I know that everybody, like the other side, you know, are all spying and watching and everything like that, but the law is the law. And what you can't do is, when it's actually being painted into a set black and white picture, it is what it is. Now I know they obfuscate, and I know they muddy the waters, and I know they actually literally fabricate, you know, so that they get it as if it looks as if it's in their favour. Right down by the sea now, right on the coast. It's beautiful, nice vitamin C for everybody there. Loads of ships out in the bay. But so that's what we're going to do. We're going to actually set precedent, and we're going to get case law that is under GDPR, not just under the deed of assignment, right? Not from 1969 or wherever it, a big jump was, right? We're going to get it from 2025, talking about GDPR. They must have put these new bloody bumps in the road. This is a major route here, you know. I know it's a different subject, but they're changing all the roadways, which is why they put all these bloody bumps in, and they're making a lot of it one way. It's one way, you know. Got rid of all the route going in. There's some rocks over there. Oh man, bloody! And there's loads of seals sitting on them rocks. And there's a massive colony of seals just further up, just along. Well, you can't see it, but oof! Never used to have these bloody lumps here. Yeah, massive colony next to the lighthouse, St. Mary's Lighthouse. And we had loads of these orca killer whales up a couple of weeks ago, and one of the boats that we were on last year when I was out, you know, they were like filming all the orca, and it was like, oh, this is amazing, and obviously the tourists are there and it's all great for them. But all I'm thinking of is like them poor bloody seals, they're coming up to eat the seals. Yeah, it might be nice for some holiday maker to come and see, you know, a big whale swimming through, but all them poor bloody baby seals gonna get eaten before they've had a chance to do anything. But anyway, it's back to the precedent. Don't worry, I haven't forgotten. But yeah, so we're gonna do it, and we will get a precedent set in case law, so that everyone will, you know, you'll not have to use Van Linn after that, right? You'll just have to use whatever name that we have on the case. 2025 case law, GDPR with the breaches from these debt collectors. I need to get parked up here. in this little, it's a tiny little train station. This is where we get the raw dog food from for little Mousy. My God, there's not much space, mind. I think I'll just have to pull back out of here again. Yeah, so anyway, we've got this all lined up now, and we will be getting the people razor sharp on, you know, their knowledge of GDPR and of the process. I think I've shot myself in the foot here. I think I might have to completely go the opposite way and reverse out. So, you know, we'll be able to start holding them to account even better, you know. But we need to move it away from, you know, the county courts, because the experience that these district judges have, or even their attitude, you know, I mean, they actually said as well, one of them said, well, where did you get that information from? You know, you're just getting this information off the internet. Well, is the law not the law? Right, can you, watch, I'm not turning me back on you, but I'm just having to reverse out, and there's a car there. I'm not turning me back on you. I say that as I turn my back on you, but you know what I mean. Dodgy ass here, like. So someone's jammed the whole roadway up. I'll just park in the middle of everything. No, we'll not have to worry about you. Right. And I am going to park up there. Hang on. So anyway, you've got a lot to be looking forward to. The people that have that got like the knockbacks, you know, we're going to go over their cases with them, and we'll see if we can assist them in getting an appeal ready, and see if we can get them into Chancery as well, and you know, and then put it forward correctly, where you've got judges that are there that have experience in data, because they specialize in data, but also in the unconscionable conduct of the actual debt collectors, because their conduct is hideously unconscionable, and it's actually perjury in a lot of ways, but you know, you'd never be able to prove that, but I mean, it's disgusting. And they'll have the experience on how to deal with these types of cases, whereas the county courts just haven't got it. They've got a concurrent jurisdiction where they're allowed to hear equity, right, when we're invoking equity in the court, but they just don't get it. And it's like, well, you know, I'm coming from a totally different angle, and you know, it's nothing to do with what we're doing. Is we're doing a breach of data, and we can prove the breach of data, and they're just like, a lot of them just literally don't want to actually help. They don't want justice. So that's why we're going to change it up. Anyway, so I best go now. I'll go and get some raw food for little Mouse, and then get back into the house, make sure he's okay. So I'll chat again there, and leave any comments that you want, and any questions or whatever, and we'll have a chat soon. Take care, everyone. Bye. Hey, I'm back. I thought I would do a part 2 of that video. Just need to reverse out of here again now. This is not the greatest place to try and park, but it's where we can get little Mousy's raw food from, because he only eats raw food, raw meat, you know, which, you know, he is a real carnivore. So horrible as it is, nature is nature, isn't it? So it's quite a handy place to be able to go and get it. So difficult to park, but anyway, so I was just talking about the GDPR claims. And think I've got to go and speak to some people today about this and get it really sharpened up. It's all been filed in Chancery. It's very interesting times, and we're in a race now with a few other members to see who can be the first ones to get case law in Chancery. So let's see who gets it. That'll be fun. But I know that I had done a few videos there where we were going over some sort of like information on trusts. So, and I had been covering, you know, the 3 certainties of a trust. I don't think I've come the right way here, you know that. Not that it matters. I need to go and get some chicken as well, like chicken wings. He likes to crunch on chicken wings, just raw. But you can get them from there, but I don't like them. Well, not that I eat them, but they look disgusting. And I'm the one that has to pick them all up. So I'm gonna go to a normal shop. It's busy around here. But anyway, so we're covering like the 3 certainties on trust law, which is exactly what you need to have to make sure you have a valid trust, which is the certainty of intention. The intention, what is the intention? What are you doing? Is it creating a trust? Which we use that famous case law again. We only deal in facts. We only deal in law. No opinions here. And that was like Paul versus Constance. So hopefully if you don't know what I'm talking about, just go and watch that video. But then we were talking about the certainty of subject matter, which is what is the actual matter or the item that you're going to be placing the asset in the trust. What is it? And we used again case law, the London Wine Company. Again, talking just on facts, just on law, not interested in anything else. And then also the other certainty, the certainty of objects, which was McPhail versus, I can't remember the second name now, but anyway there, and that one, I'll have to check that one. Not too bad a memory though, I remembering all the others. That there showing that you must make sure that you have the not just it doesn't have to be an actual individual name, it can be a class, but as long as it's written out correctly. So you have what they call the is not test, which was the guy that the Lord, I can't remember his name, it was a really funny name, used for that actual case. And you know, is that or isn't that, do they not fit into that class of beneficiary? And then you can have it written out just as a class. So there's the 3 certainties there, and covered that. But we're going to go over a bit more, and I'm going to share a bit more just to actually show you even more case law, which will indicate 100% to you, and it'll show you point blank that you have got every single right, a lawful right and a legal right to create your own trust. You do not need permission from anybody. You do not need a qualification at all, and you don't need to even ask anyone else to do it for you. You can do it all yourself, and it's just got as much power as if some solicitor that did it that wouldn't give a monkey's what he'd actually wrote in there as soon as he'd finished writing it, and would probably never ever look at it again, you know, once they'd actually written it. And would use, what would they use to do it, do you reckon? What's called a template. Yeah, they use a template as well. So you can and have got the 100% the legal and lawful right to create your own trust, and it stands just the same as anyone else's. And again, even there, like that Paul versus Constance, that's a good case law that shows you, because that, you know, that trust there that they're talking about, there was nothing ever written down. There was nothing ever, they never ever even used the word trust. You know, it was just the actual words themselves. Are you going out that way? Are you turning? That he used, that created a solid intention, and that created a trust, and that trust stopped you know, the wrong woman from getting their hands on the money that he wanted someone else to have. There you go. So, you know, we're going to go over a lot more on the actual creation of it and how to do it, and what case law that you need to back, just to back it up. I mean, you know, so you got it in your head that it'll show you that any time that it would ever get challenged, you know, that you can actually back it up with case law. And as you've got your actual, because you should actually have an express written trust. You know, you can just have the word, but you know, it's going to be far harder to actually stand on your in your corner and fight your corner if you haven't got it written down and can't refer to anything. Woo! Sneaking out of that driveway. So I mean, I'm just going to add on to this chat, because I'm just popping up to the next shop for little Mousy. All this shopping, you know, we're just going out doing shopping. Don't do it for ourselves, do it for Mouse. Run around like you're looking after. You're either looking after him in the house, or you're running around to get him stuff outside the house. He gets looked after, that's for sure. Yeah, so, you know, and we're going to show you sort of like templates where you can actually use your own to create. And there's two different versions that we're going over now that our members are using. And I'm not going to really explain the two different ones and the separate one that we have. And obviously I know that no matter what you do in a private group, no matter how private it is, there's always going to be someone who will take what they're not meant to take and share with others that should not have, you know. So, and I you know, I know for a fact that other people are already talking about certain words, you know, and it's been mentioned in forums, or what do you think of this, and they've used this word, and it's like, oh no, I don't know anything about that, we'll have to find out more about that, you know. So I'm not going to mention it in here, but on how to actually create them. And we know already, reversing into me, that these have good stand-up quality in a court, because that's where we've been and tested them, in the court. We know it because we've done it, and we stopped the repossession of that home with this very document. So, you know, if anybody wants to try and tell me it doesn't work and that it's not real and that they don't stand up, well, we best go and ask them judges then. They must be stupid as well then, are they? Because they certainly thought that it was good enough to stop a repossession of a house. So either the deed was good, or the judges were stupid. You can decide which one it was. So we're gonna obviously in the private group we have regular live calls every Thursday. I had one just last night, which we were actually talking a lot more about the council tax thing, remembering this, and it's the same thing. We're not giving legal advice to anyone. I give no advice, legal, financial or marital at all. You know, and your decisions are your decisions, and you do what you want. And I've never told anyone ever, like, don't do this and don't do that, don't pay for this, don't pay for that. Never, ever, ever. And I don't ever challenge council tax. I don't ever say, well, you know, show me my obligation, or any of that nonsense, or, you know, like, this is all illegal and you're not. No, never, ever, ever. And I think you try and do that, right? You're on a losing game and you are in deep trouble, you know. But what I do is I actually use equity in GDPR to manage the actions once you've gone past that point. So not the actual council tax itself, not the Local Government Finance Act 1992. We don't challenge it, we actually use it. Nothing like that. Not the authority to charge, not the authority to enforce. We don't challenge it, we don't question it, we don't argue with any of it. So all we do is we actually indicate and show unconscionable behaviour of the councils and the debt collectors once they start the actual process of enforcement. Yes, you can do it. You just have to do it correctly. You have to do it legally, would be the way to put it. Legally, you know. And when they don't do it legally, they're the ones that are in the trouble, not you, you know. So and this is also to do in certain aspects, like, you know, with a private trust as well. So I just thought I'd add that little bit on, you know. As I had a few more minutes, I'm gonna pop in there and get some unfortunate for the chickens, some chicken wings for little mouse to crunch on. He likes crunching on, just raw again, you know. You don't ever cook raw. And you know, he likes to have a bit crunch on them. Really good for the teeth, crunching on the bones, you know, fleshy bones. I know it doesn't sound very nice, but you know, they are you know, a carnivorous animal, aren't they? You know, that's what they're meant to do in nature. I'm not eating it. But anyway, so I just thought I'd just add that a little bit on, and that'll do me. I'm going to do a couple of more TikTok videos. Not going to do any dancing on them though. Later on today, and got a ton of like information and content that we're putting into the classrooms on the council tax one, as well as on the actual debt one, and you know, a couple of others as well. Got a lot of work to do, but it really benefits our members. So if you want to actually have a look at the private group, get yourself into the description, click it, go and have a look. It's even got like a free trial, and it's like, it's definitely the value is off the scale, you know. It's not even very much money, but it's like the value is off the scale. But make sure you do that. And also remember, we're going to start advertising very soon for Checkmate the Matrix 2026, which is going to be in May 2026. Already booked, already sorted. Got like loads of people that we've already got, like that have said that they're going to come do talks and everything like that. So very exciting times. But this is June, so I'm going up to Scotland in a couple of weeks, going up there boating, gonna get out on the boat again. And you know, I'm actually going back to the place where I got my very first coxswain's ticket, which is like a, you know, a driving license for boats, and that was in 1983. I'm not going to the same like school, because that was a Royal Navy one in Rosyth. I'm actually going to be on the other side of the Forth, other side of the river, the southern side, which is going to be in Queensferry. There's got a school there, and I'm just going in 2 days boating there, get my next sort of like level up. I've got way more experience, you know, than any of them. You know, they haven't been in the middle of huge storms, you know, saving people's lives, or you know, boarding fishing boats with 1 minute they're there and the next minute they're gone, like, well, seconds, up and down in crazy waves. But you've got to go through these, and I just love being on the water. I love being at sea. It's one of my things of life. And then after that, in July next month, July, the 20th of July, I'm going to be in Dundee. We're going to do a chat in Dundee, back to where the venue that I did one maybe 5 years ago, something like that, in the middle of Dundee. So I'm actually going up to Glasgow. I'm going to be staying in Glasgow overnight on the 19th, and then the 20th I'm going to be in Dundee. We're going to do a chat all day Sunday in the Dundee, so we'll let you have some details on that. You know, put comments in there if you want, or try to get into, if you get into the group, you can leave messages for me. Don't email, because there's no emails getting answered anymore. They're not manned anymore. You know, just ridiculous trying to keep up with them. It's just not, there's just no time, literally no time. But yeah, keep an eye out for that. It'll be the 20th of July in Dundee. We will get all the subject matter, and you know, it'll be an amazing day. All right, but anyway, this is definitely it for this video, and you take care, and we'll chat soon.